session.
Thank you, gentlemen, for joining us. In just a minute, we'll begin the argument part of this case. Want to say a couple of things before we get started. First of all, I'd like to introduce the panel to you. Your panel today is Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Arnold, you are representing yourself, that is correct?
Yes, Your Honor.
Okay. And I realize you've been through this process before, but just by way of description, we're going to give you 15 minutes in just a moment, and you can give us your argument. You may reserve up to 5 minutes of rebuttal time if that's what you choose, but you'll need to add or request that from the court after you've introduced yourself and before you begin your argument. Then we'll hear from the appellee, and when we finish today, we won't make a decision. We will file a written opinion. We'll review the record, file the written opinion. It may be 30 to 60 days before that happens, though. Mr. Hibner, you may call the case.
Edward Ronny Arnold versus Bob Oglesby et al.
Yes, Your Honor. I'm Edward Arnold, pro se. I'm acting as pro se because the damages in this case,
Excuse me just a minute, Mr. Arnold. Did you wish to reserve rebuttal time?
I was fixing to reserve the time. So I've got basically 12 minutes, and I'm asking for 3 minutes for rebuttal.
All right, sir. You may proceed.
Your Honors, I'm Edward Arnold, pro se. I'm acting as pro se because the damages in this case, 1 day's wages, $180 minus withholding, is less than the fees of an attorney. This case is not about $180. It's about the right of residents of the state of Tennessee to redress public officials for not doing their job. This case began in the year 2015, and since that time, elements of this case have been before the Davidson County General Sessions Court, Sixth Circuit Court, Chancery Court, Tennessee Court of Appeals, Tennessee Supreme Court, U.S. District Court, and the United States Court of Appeals for the Sixth Circuit. Prior to this hearing, 4 writs of certiorari were docketed before the United States Supreme Court. On June 29, 2020, the Supreme Court of the United States denied the petition for a writ of certiorari in the case of Edward Ronny Arnold versus Herbert Slattery III, Attorney General of the State of Tennessee, 1912-74. This writ addressed the legal opinion of the State of Tennessee Attorney General and reporter, Title V USC 6103 and Tennessee Code Annotated 44105A does not address compensation. This legal opinion began in this court in the year 2017. In essence, the legal opinion has returned to where it began. If this court chooses not to address this issue, the legal opinion remains that employees of the state of Tennessee will not receive compensation for the Friday after Thanksgiving, the 4th Thursday in November. It'll be up to the Tennessee legislature to modify the law or leave it as is. The remaining 3 writs address the issue of unequal access to the courts for low-income minority litigants, problems with the implementations of the state of Tennessee online unemployment benefits system, and the interpretation of Tennessee Rule of Civil Procedure 4046, which all began in this case back in 2015. This case before the court is determined if the plaintiff appellant answered the questions correctly in the motion for summary judgment, and if the trial court erred in not allowing 3 witnesses to testify. A 4th witness was to refute the sworn testimony used as evidence that the plaintiff appellant's last workday was November 24, 2015. This refute was the record defendant appellant's Exhibit D, document number 119, Bentley 16, did not contain documentation. The defendant appealee complied with rules of the Department of Human Resources 1120-0610, 1120-0612, and 1120-0902. Defendant's reply to plaintiff's response to defendant's motion for summary judgment, page 2, and order granting defendant's motion for summary judgment, page 4, page 5. In that, the affidavit of Ms. Wendy Bentley was not complete. The defendant appealee was not acting on the authority of the state in violation of Tennessee Code Annotated 2013-102 in placing the plaintiff appellant on 30 calendar days special leave. The defendant appellee
Mr. Arnold, excuse me, Mr. Arnold, what response did you make to the state's motion for summary
I
judgment?
say they were all inaccurate, and I had 3 witnesses that were to come in, and they were going to
Excuse me. My question was, what response did you make in response to the motion for summary judgment?
I gave that they were inaccurate, that the statements that what they were saying was inaccurate, and I had 3 witnesses who were to testify that
Did you submit affidavits from those witnesses?
No, Your Honor, they were outside. The judge ruled these came at last. I couldn't find them. Originally, I had 18 witnesses in this case in 2015. I'm down to 3. So I was trying to find the people, and one of the persons had already left. So the judge gave a bench order that the only thing that would be allowed in that hearing was a sworn testimony, which was only the 2 affidavits they had from Ms. Bentley and from this other person.
Well, how long were you aware that this motion for summary judgment had been pending?
Your Honor, I was not allowed to go and talk to these people, and I had a meeting with Mr. Jenkins in his office, and I gave him a list of these people, and I'm not allowed in the state office. I can't go see these people. These people are concerned that if they go and they testify, they may lose their job.
Well, did you attempt to subpoena the people to testify?
They were subpoenaed. They were subpoenaed outside waiting. They were all subpoenaed.
But so you had them subpoenaed, but did you subpoena them to take their depositions or to?
No, Your Honor. No, Your Honor. They were subpoenaed to testify in court, and they were to testify that the record that they had in there was not accurate. They were to testify that according to the Tennessee rule.
We can't hear what they may have said.
I understand.
My question, we can only go by what's in the record. And my question is, I think you've answered my question, that you filed no affidavits in response to the motion for summary judgment.
That's correct, Your Honor.
Did you file a response to the statement of undisputed material fact?
I believe so. I believe I did so.
All right, go ahead.
This case began in Davidson County General Sessions Court November 27, 2016, and was before this court October 4, 2017. The issue was the right of citizens and residents of Tennessee to redress public officials who do not do their job. More than 3 years later, we are before this court with the same issues. Issue number 1. What day or date are employees of the state of Tennessee required to work to receive benefits for the federal state holiday of Columbus Day? Issue 2, what was the plaintiff appellant's last day of work? Rules of the state of Tennessee Department of Human Resources 11-2006.15 are specific on holidays. Employees must be in an active pay status for the major portion of their scheduled workday immediately preceding a holiday to be eligible for the benefits of the holiday. United States Code 5 U.S.C. 6103 specifies federal holidays which fall on a Monday. Martin Luther King Jr. Day, January, President's Day, February, Easter Monday, April, Memorial Day, May, Labor Day, September, Columbus Day, October. Rule 11-2006.15 specifies a state employee must work the Friday before the Monday to receive the benefits of that holiday. The benefit is state offices are closed on that Monday for a 3-day weekend. In this case, for the state and federal holiday of Columbus Day, the second Monday in October, this was Friday, October the 9th, 2015, for the date of Monday, October 12, 2015. This holiday is controversial because Tennessee Code Annotated 44105A13 gives the sitting governor the option of keeping state offices open the second Monday in October and closing state offices the Friday after Thanksgiving, the 4th Thursday in November. The defendant appellee, as represented by the State of Tennessee Office of the Attorney General Reporter, contends employees of the state of Tennessee must work the Wednesday before Thanksgiving, the 4th Thursday in November, to receive Thanksgiving and the modified observance of Columbus Day as holidays with pay due to the closing of state offices. Are state employees required to work Friday or Wednesday? This is a narrow question of law the courts in their discretion have chosen not to address. The second narrow legal question is the last working day of the plaintiff appellant. The warrant notice issued to the plaintiff appellant on October 26, 2015 gives the last work day is November the 25th, 2015, the Wednesday before Thanksgiving, the fourth Thursday in November. The discretionary leave of 30 days administrative leave with pay issued October 26 gives the date of November 24, 2015. In the motion for summary judgment, the trial court chose not to address the issue of Tennessee Code Annotated 44105A13 and chose not to address the last working day. The court relied on sworn testimony in the form of affidavits to which one witness was to refute their affidavit. As stated in the brief, Judicial Labor and Finality, page 39, the general rule for determining whether an order on appeal is final is whether the order constitutes an end to the judicial labor in the cause and nothing further remains to be done by the court to effectuate a termination of the cause as between the parties directly affected. SLT Warehouse Company versus Webb, Florida, 1974. In this case, these two narrow legal questions have not been addressed in state or federal courts. One additional question was raised in this court by the State of Tennessee Attorney General Reporter, Title V of the United States Code 5 USA 6103, and a modified observance of the State of Tennessee Code Annotated 44105A13 do not address compensation. This question, compensation, was on petition for a writ of certiorari to the United States Court of Appeals for the Sixth Circuit in the Supreme Court of the United States, Edward Ronny Arnold versus Herbert Slattery III, but was denied on June the 29th, 2020. This denial does not directly affect this case, as the plaintiff appellant was qualified in the year 2015 to receive compensation, and the defendant appellant has not denied they knowingly did not respond to repeated efforts to collect the unpaid wages. I think I'm out of time.
No, sir. You still have 2 minutes.
Well, I had a rebuttal.
Yes, sir. Yes, sir. We've reserved your rebuttal time.
Oh, okay. This case seems silly, a civil action for 1 day's pay of $180 minus withholding, but it becomes complicated when the State of Tennessee Attorney General Reporter issued a legal opinion in a brief to this court. The legal opinion stated defendant appellant in not paying earned wages did not violate Tennessee Code Annotated 39-16-402A3 official misconduct. It's Title V of the United States Code 5 USA 6103 and the modified observance for the state of Tennessee do not address compensation. The special leave, administrative leave with pay, gives the last work day as November 24, 2015, but the warn notice gives the last work day as November 25th, 2015. 2 of the 3 witnesses were to testify the warn notice and issuance of administrative leave pay did not coincide with established pay dates. In addition, the 3 witnesses and a 4th witness for the defendant appeal was testified before the court. The dates for the 30-day administrative leave pay did not comply with the rules of the Department of Human Resources 112006.25 as shown in Appendix 3. I think I'm out. Thank you. I think I'm out.
Yes, sir. All right. Mr. Jenkins, we'll hear from the appellee.
Good morning, Your Honors, and may it please the court. Oh, I'm sorry, Your Honors. The clock doesn't. There it is. Good morning, Your Honors, and may it please the court. Taylor Jenkins of the Office of the Tennessee Attorney General on behalf of the defendant appellee, the Commissioner of the Department of General Services. Your Honors, this case has an admittedly complex procedural history, but the issue before the court today is simple. We are asking you to affirm the trial court's ruling granting summary judgment to the Commissioner. Trial court's ruling is proper for 3 reasons. First, because the Commissioner is entitled to sovereign immunity. Second, because plaintiff fails to state a claim upon which relief can be granted because Tennessee Code 44105 does not expressly create or confer a private right of action. And third, because plaintiff is not entitled to Columbus Day holiday compensation as a matter of law. Now, first and most importantly, the Commissioner is entitled to sovereign immunity pursuant to Tennessee Code 2013-102A.
Let me stop you just a minute, Mr. Jenkins.
Yes, sir.
Let's talk about something a little bit more basic, and that is when the motion for summary judgment was filed, tell us what was before the court at that time, what your proof was and what Mr. Arnold's proof was, as best you can recall.
Yes, Your Honor. I filed 2 affidavits in support of my motion for summary judgment. And that was one affidavit from a human resources officer, a payroll officer, and one affidavit from the Deputy Commissioner of the Department of General Services. And in response, Mr. Arnold filed a response to the motion, and he filed a response to the statement of material facts. But those responses were just general denials to our statements, or they were denials supported by hearsay, or they were denials supported by just irrelevant pieces of documentation. He did not have any affidavits from anyone. And as he was saying, he did subpoena 3 witnesses for trial, but he did not have interrogatories that he had served on anyone properly. He did not have affidavits in response to our motion for summary judgment.
Did the trial court make any findings regarding the evidence that was before it on the motion for summary judgment?
The trial court found that Mr. Arnold's responses were not compliant with Tennessee Rule of Civil Procedure 56.03, and therefore deemed the commissioner's statement of material facts as undisputed for purposes of considering the motion. And based on those statements of material fact, the trial court determined that summary judgment should be granted for all 3 of the aforementioned reasons.
All right, sir. Thank you.
So first and most importantly, the commissioner is entitled to summary judgment to sovereign immunity pursuant to Tennessee Code 2013-102A. And this court has previously held that for a state official to establish sovereign immunity, 3 elements must be established. And those are that it is an action against a state official, the state official was acting by authority of the state, and that the action seeks to reach the state, its treasury, its property, or its funds. Now, Your Honors, the first and third elements have been essentially undisputed throughout this litigation. Mr. Arnold acknowledges that this is a suit against Bob Oglesby, Commissioner of the Department of General Services. And in fact, the civil warrant that was filed originally in General Sessions Court and became the complaint in Circuit Court lists the address as 312 Rosa L. Parks Avenue, which is the address of the department's office in Davidson County. And likewise, he acknowledges that any judgment against Commissioner Oglesby would be paid from the state treasury. Plaintiff does argue, however, that the commissioner was not acting by authority of the state in determining that Mr. Arnold was not eligible for Columbus Day holiday compensation. But the record in support of the motion for summary judgment clearly establishes that the commissioner was acting by authority of the state. And that is because in 2015, the governor determined that the Columbus Day holiday would be recognized the Friday after the 4th Thursday in November, so Friday, November 27th. The Tennessee Department of Human Resources sent a letter to all appointing authorities and human resources officers stating that the Department of Human Resources considered Monday, October 12th, a regular workday, and Friday, November 27th, a state holiday. The Department of Human Resources policies and employee manual also state that to be eligible for holiday compensation, a state employee must either work or take paid leave on the last regularly scheduled workday immediately preceding the holiday. So in applying those directives and policies, the Commissioner of the Department of Human Resources determined that Mr. Arnold was not eligible for holiday compensation in accordance with state authority. And for that reason, the trial court's ruling that summary judgment was appropriate on the basis of sovereign immunity is proper and should be affirmed. Now, second, Your Honor, even if this court determines that sovereign immunity has not been established, plaintiff fails to state a claim upon which relief can be granted because Tennessee Code 44105 does not expressly create or confer a private right of action. Throughout 4 years of litigation in this case, plaintiff has repeatedly and consistently said that this is a lawsuit for violation of Tennessee Code 44105. And that statute is merely a definitional statute. It establishes office hours on holidays. It gives the governor discretion to move the Columbus Day holiday, and it details several other aspects of state holidays, but it does not create or confer a private right of action. And this court has held that courts must not excuse pro se litigants from complying with the same substantive and procedural rules that parties represented by counsel must observe. The court should not create a claim for pro se litigants where none exists. For that reason, the trial court's ruling granting summary judgment to the commissioner was also appropriate. And third and finally, Your Honors, plaintiff was not entitled to Columbus Day holiday compensation as a matter of law. The undisputed material facts show that plaintiff's last day of pay for the Department of General Services was Tuesday, November 24th, 2015. To be eligible for holiday compensation, Mr. Arnold would have had to either work or take paid leave on Wednesday, November 25th, which would have been the last regularly scheduled workday immediately preceding the moved Columbus Day holiday. But by that point, his WARN notice had ended, his position had been abolished, and he had been terminated from the Department of General Services. And I want to be clear, Your Honors, that Mr. Arnold worked and was paid for working on Monday, October 12th, and that is in the record. But he was not paid for the Columbus Day holiday because it was not observed until Friday, November 27th, and therefore he was not eligible for holiday compensation. For those three reasons, Your Honors, we are asking you to affirm the trial court's ruling granting summary judgment to the defendant. Your Honors, I also acknowledge that plaintiff has put forth numerous issues in his appellate brief and in his reply brief. And while it is the commissioner's position that those issues were not properly raised in trial court or not properly presented through his appellate briefs, in acknowledgement of the complexity of this case, I am happy to answer any questions you may have.
Seeing none, we'll hear from you, Mr. Arnold.
Thank you, Your Honors.
Thank you, Your Honor. I think it's important to note before this court that Mr. Jenkins referred to the three positions that for sovereign immunity. He did not tell you that those definitions came from this case, from where this court ruled in Edward Arnold versus Oglesby, M17-00808 R3, that Mr. Oglesby was not acting on the authority of the state. When that was referred back to the court, to the trial court, Mr. Jenkins changed the status of the case to what's called appeal from general sessions, which meant that nothing that was ever presented in this case could be used. That situation is currently in a writ before the Supreme Court. In Edward Ronny Arnold versus Herbert Slattery, Third State of Tennessee Attorney General Report number 1967, docket is 1394, where Mr. Jenkins, when this was remanded back to the court, changed the status of the case, and to which someone handwrote on the court order that it was a non-jury. That's been an issue in here where Mr. Jenkins modified that, and that's been a battle about not being able to allow to have that information. First of all, this case is based on dates. The issue is if the plaintiff is eligible for wages for the substituted state holiday of Columbus Day as codified in Title V. Tennessee, the rules of requires on 1120-06.25, you can only put a person on 10 days administrative leave with pay. That's work days. After 10 work days, you have to have permission from the Commissioner of Human Resources. That was not done. And in this case, the three witnesses were to testify that Mr. Oglesby, as commissioner, and his all did not go through that process. So therefore, they were not acting on the authority of the state. They were in violation. They were not eligible for sovereign immunity because the rules do not allow them to change work days into calendar days. Thank you, Your Honor.
Thank you. We will review the record. We will attempt to get you an opinion as quickly as possible. We certainly appreciate your participation here by video oral argument. We again want to thank Mr. Hibner for being the mastermind behind all this, and appreciate the AOC staff for figuring out a way so that we can conduct these oral arguments in this difficult time. But we appreciate it, and that will conclude the call of the docket for this morning. Mr. Hibner,
This honorable court is now in recess until 1 p.m.
thank you.